You may be seated.
Okay, before we bring the members of the jury in, I do want to caution the audience against any audible or physical reactions to their verdict. If you do feel overcome with emotion at whatever the verdict might be, just exit the courtroom. We don't want to have any thing going on in the courtroom that will cause any sort of undue attention to be drawn to the proceedings. So I'll leave you with that cautionary statement. With that, we can bring the jurors in. In this cause number 122011718, the state of Texas versus Brandon Daniel. Let the record reflect that counsel for the defendant, as well as counsel for the state, and all 12 jurors are present and seated in the courtroom. I did receive a message from the bailiff that you have a verdict as to the special issues in this case. Is that correct?
Yes, Your Honor.
Would you pass that verdict to the bailiff? If the defendant would please rise. This is, again, in the same cause number as previously read. These are the answers to the special issues. Special issue number 1. Do you find from the evidence beyond a reasonable doubt that there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society? The answer is yes. 8:40 p.m., February 28th. Special issue number 2. Taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, do you find that there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment rather than a death sentence be imposed? The answer is no. 10:30 p.m. on today's date. Certification. We, the jury, having agreed upon the answers to the foregoing issues, return the same into court as our verdict, signed by the presiding juror at 10:30 p.m. You may be seated. Ladies and gentlemen of the jury panel, I will ask you if this verdict that you have returned and that I have just read and the answers to these special issues are your individual verdicts in this case as well, and if it was unanimously reached. If you would all please raise your right hands if that is correct. Let the record reflect that each juror does have their right hand raised. You may sit them down. Does either side desire to have the jury polled at this time?
Not mistaken. We do, Your Honor.
Ladies and gentlemen of the jury, what I will ask you is basically the same that I just asked you. If this verdict that your jury has returned as to the answers to the special issue questions represents your individual verdict in this case as well. I will start with the presiding juror, Juror Hernandez.
Yes, Your Honor.
Juror Gonzalez. Juror Gaston,
Yes, Your Honor.
Juror Soto,
Yes, Your Honor.
Juror Trevino,
Yes, Your Honor.
Juror Takasumi,
Yes, Your Honor.
Juror Jimenez,
Yes, Your Honor.
Juror Timberina,
Yes, Your Honor.
Juror Smith,
Yes, Your Honor.
Juror Grom,
Yes, Your Honor.
Juror Triplett,
Yes, Your Honor.
Juror Galvan.
Yes, Your Honor.
The court does find that this verdict is a unanimous verdict that has been reached by this jury. Before I formally pronounce sentence as required by law, let me inform you, Mr. Daniel, that under the Texas law, the judgment of conviction and sentence of death is mandated by the answers that the jury has given and will be subject to automatic review and appeal by the Texas Court of Criminal Appeals. This review is mandated by Texas law, and their appeal has priority over all other types of cases that will be pending. Mr. Daniel, if you're indigent, you're entitled to a court-appointed counsel to represent you at that point, unless you choose to proceed pro se and exercise your right to self-representation. This would be against the court's advice. The court has previously found you to be indigent and entitled to court-appointed counsel, and counsel has represented you very ably. This court will also appoint experienced counsel to represent you on an appellate level if it is your desire to do so. Is it your desire to have court-appointed counsel at that level, Mr. Daniel?
Yes, Your Honor.
Okay. On another note, you also have a right to pursue a writ of habeas corpus after this date. Do you wish the assistance of counsel in the pursuit of that as well, Mr. Daniel?
Yes, ma'am.
This court will now appoint the Office of Capital Writs and Director Brad Levinson to represent you in pursuing your writ of habeas corpus. That will become effective once your trial counsel has completed all of their obligations with regards to motions for new trial and such being filed after today's date. The appeal is automatic, as I stated earlier. The clerk will transmit notice of this conviction to the court within 30 days of today's date. The court will then have 60 days in which to review this case, having been given priority over all other non-death penalty cases. In the event that the writ is filed, the defendant has 180 days from the date of appointment of writ counsel, which is today's date, to file the writ. If there is no writ filed, you have 45 days from the filing of that state's appellate brief to file documents in reference to this appeal. Do you understand those rights that I've just explained to you, Mr. Daniel?
Yes, ma'am.
Understand that if there is a mandatory appeal and that any formal pronouncement of sentence today will not include your date of execution, is there anything that you wish to say before this court proceeds with the pronouncement of sentence?
No, ma'am.
Would you please stand? On behalf of the citizens of the state of Texas, Brandon Daniel, the jury having found you guilty of the capital murder of Jaime Padron and having returned a unanimous verdict to special issues 1 and 2, this court hereby sentences you to death by lethal injection. It is therefore the order, judgment, and decree of this court that you will be remanded to the custody of the Travis County Sheriff to be delivered to the Institutional Division of the Texas Department of Criminal Justice, where you shall be continuously confined until 6 p.m. on a future date, to be determined when the proper authorities will administer lethal injection sufficient to cause your death. You may now be seated. Sentence has now been formally pronounced on the provisions of our law. Are there victims that wish allocution at this time?
Yes, Your Honor.
You may proceed.